Something changed overnight, and the gun owners who know about it are not sleeping well. Across America right now, in kitchens and living rooms and gun shops and online forums, the same conversation is happening. People who have owned firearms legally for decades. People who have never broken a single law. People who have done everything right, every single time. And they are scared. Not the kind of scared that comes from political noise or media exaggeration. The real kind. The kind that comes from reading the actual ruling and understanding exactly what it says. Because what the Supreme Court just did is something that legal experts on both sides of the gun debate are calling unprecedented. And the fear spreading through the gun owner community right now is not irrational. It is not paranoia. It is a direct and completely reasonable response to what is actually in this ruling. We are going to tell you exactly what it says, exactly why it has millions of law-abiding gun owners genuinely alarmed, and exactly what legal experts say you need to know right now. Stay with us, because this one is different from everything that came before it. Let us start with something that almost never happens in Supreme Court decisions on gun rights. This ruling did not come down on a simple majority. It did not come down 5-4 or 6-3 in the way most contentious gun decisions have in recent years. The way this ruling is structured, the way it is written, and the legal framework it establishes have created a situation where even justices who are considered strong Second Amendment supporters acknowledged that certain implications of the decision are going to be deeply uncomfortable for gun owners across the country. That is what makes this different. That is what makes it terrifying to people who have been following Second Amendment law closely. When the justices who are supposed to be on your side are writing language that gun rights attorneys are now quoting to each other with alarm, you know something significant has shifted. Let us talk about what actually happened and why it matters so much. The case centered on a question that sounds technical, but has enormous practical consequences. The question was this: under what circumstances can the government impose restrictions on gun ownership based on administrative determinations rather than criminal convictions? In other words, can the government limit your Second Amendment rights not because a jury found you guilty of a crime, but because a government agency or a court made an administrative finding about your situation? This question has been lurking in American gun law for years. It has been argued in lower courts. It has generated conflicting decisions. And now, the Supreme Court has addressed it in a way that has sent shockwaves through the gun owner community. The ruling established what legal scholars are now calling an expanded administrative authority framework. What that means in plain language is this: the court found that under certain defined circumstances, government agencies and courts can make determinations that affect a person's Second Amendment rights without that person having been convicted of any crime, without a jury of peers finding them guilty of anything, based on administrative processes that have much lower standards of proof than a criminal trial. Read that again slowly. You could lose rights without being convicted of a crime, based on a government process, with a lower standard of proof than what a criminal court requires. That is the sentence that is keeping gun owners up at night. And it is directly from the legal framework this ruling established. Now let us get specific about what this framework actually allows. Because the details matter enormously here, and the fear this ruling is generating is rooted in those details. The ruling identified several categories of administrative determination that it found could constitutionally affect Second Amendment rights. The first involves mental health adjudications. This is not entirely new territory. Federal law has long prohibited individuals who have been adjudicated as mentally defective or committed to a mental institution from possessing firearms. But the ruling expands the framework around what counts as a qualifying adjudication and, critically, how that adjudication can be made, challenged, and reviewed. Under the new framework, the standard for what constitutes a qualifying mental health adjudication has been interpreted in a way that is broader than many gun rights attorneys expected. And the process for challenging such an adjudication, for fighting back when you believe one has been incorrectly applied to you, has been defined in ways that put a significant burden on the gun owner rather than the government. The second category involves domestic relations determinations. The ruling addresses how certain civil court findings in domestic relations cases divorces, custody disputes, protective orders, can affect Second Amendment rights. This is an area where many gun owners have found themselves caught in legal situations they never anticipated. A protective order, even a temporary one, even one based on disputed allegations that are never proven in a criminal court, can under this framework result in restrictions on your ability to possess firearms. The third and perhaps most alarming category involves what the ruling calls risk-based determinations. This is the category that has generated the most fear in the gun owner community, and for good reason. The court found that administrative or judicial determinations that a specific individual poses an elevated risk to public safety can constitute a sufficient basis for temporary restrictions on Second Amendment rights, provided certain procedural safeguards are in place. The court was explicit that this category must be handled carefully and that robust due process protections are required. But the existence of the category itself, the acknowledgement that a risk determination short of a criminal conviction can affect gun rights, is what is alarming gun owners and their attorneys. Because here is what gun owners understand about risk-based determinations that the legal language sometimes obscures. Risk is not an objective fact. Risk is an assessment made by human beings working within systems that have their own biases, their own pressures, their own institutional incentives. When you give government officials the authority to make risk determinations that affect constitutional rights, you are giving them enormous discretionary power. And discretionary power, history shows repeatedly, does not always get exercised in ways that respect the rights of the people it is applied to. This is why the gun owner community is afraid. Not because they believe they personally are mentally unwell or domestically dangerous or a risk to public safety. They know they are not. They have clean records. They have been responsible owners for years or decades. But they also know that being caught up in a system of administrative determinations is not something that only happens to people who deserve it. It happens to people who are wrongly accused. It happens to people who get caught in messy divorces. It happens to people whose neighbors file complaints. It happens to people who say the wrong thing in the wrong context and have it reported to the wrong authority. The question they are asking right now, the question that is generating genuine fear, is this. If the government now has a broader administrative framework for affecting Second Amendment rights, how easily can an ordinary law-abiding gun owner end up in that framework? And how hard is it to get out once you are in? Let us talk about what legal experts are actually saying in response to these concerns, because the picture that emerges from the gun rights legal community right now is one of serious alarm combined with active preparation. The first thing Second Amendment attorneys are pointing out is the due process question. The ruling does include language about procedural safeguards. It does say that administrative determinations affecting gun rights must come with notice, with an opportunity to be heard, and with meaningful review processes. But what those safeguards look like in practice, how robust the notice requirement is, how meaningful the hearing opportunity is, how thorough the review process is, all of that is going to be determined by lower courts applying the ruling to specific situations. And lower courts have a history of interpreting procedural safeguard requirements in ways that satisfy the legal standard on paper while providing much weaker protection in practice. The second concern that legal experts are raising is the interaction between this ruling and existing state-level laws. Red flag laws already exist in more than 20 states. Emergency protective orders exist in every state. Mental health reporting systems that feed into firearms, background check databases exist across the country. All of these existing systems now potentially operate within a new and broader legal framework that the Supreme Court has validated. The ruling does not create these systems, but it may provide them with stronger constitutional backing than they had before. And that stronger backing could make it easier for states to expand them, to make them broader, to make them faster, and to make them harder to challenge. The third concern is evidentiary. The standard of proof required for an administrative determination that affects gun rights is lower than the standard required for a criminal conviction. In a criminal case, the government must prove guilt beyond a reasonable doubt. That is a very high bar. In administrative proceedings, the standard is often preponderance of the evidence, meaning more likely than not. Or in some emergency proceedings, even less than that. A court can issue an emergency order based on credible allegations before any meaningful evidence has been presented or tested. Under the framework the ruling establishes, that administrative determination can affect your Second Amendment rights even before you have had a real opportunity to contest it. Let us talk about the specific populations of gun owners who are most immediately affected by this ruling. Because while every gun owner in America should understand what this ruling means, some groups are facing more immediate and direct implications than others. Veterans are one of the most concerned groups right now. The Department of Veterans Affairs has a system for reporting veterans to the National Instant Criminal Background Check System when VA determinations find them unable to manage their own financial affairs. This system has been controversial for years, with gun rights advocates arguing it unconstitutionally strips veterans of Second Amendment rights based on administrative financial management determinations that have nothing to do with dangerousness. The ruling's expanded administrative authority framework raises significant questions about how this system will be interpreted and applied going forward. Older Americans are another group paying close attention. The intersection of aging, cognitive health, and firearms has been an increasingly active area of legal and policy debate. As the population ages, as questions about cognitive decline become more common, the potential for administrative determinations related to mental fitness to affect the gun rights of older Americans is a real and growing concern. The ruling's framework for mental health adjudications is being read very carefully by attorneys who represent older gun owners and by organizations that advocate for their rights. People who have been through contentious divorces or custody battles are also deeply concerned. The domestic relations category the ruling addresses is one where ordinary people find themselves in court proceedings they never anticipated, where allegations are made that are disputed and sometimes false, and where temporary orders are issued quickly based on limited evidence. The potential for temporary protective orders and other domestic relations court actions to affect Second Amendment rights under the ruling's framework is a major source of anxiety for people in these situations. And perhaps most broadly, gun owners who are politically active, who advocate publicly for their rights, who engage in debates about gun policy, are watching this ruling with concern about its potential to be used as a tool against people who are simply exercising their First Amendment rights to speak out on Second Amendment issues. This may sound extreme, but the history of administrative power in America includes examples of political advocacy being used as evidence in administrative proceedings in ways that most people would consider inappropriate. The concern that an expanded administrative authority framework for gun rights could be used in ways that were never intended is not paranoia. It is an informed reading of how administrative power has been used in other contexts. So what should gun owners actually do right now? Because understanding the threat is important, but knowing how to respond is more important. The first and most urgent recommendation from Second Amendment legal experts is documentation. Build a clear, documented record of your responsible gun ownership. Your purchase records, your safety training certificates, your range memberships, your licenses and permits, all of it. If you are ever subject to an administrative proceeding that affects your gun rights, having a comprehensive documented history of responsible, lawful ownership is the most powerful evidence you can present. The second recommendation is to understand every administrative system that currently has information about you that could be relevant to your gun rights. This means understanding what is in your medical records that might be relevant to mental health determinations. It means understanding what civil court records exist about you. It means understanding what law enforcement contacts you have had, even minor ones, that are documented somewhere. Not because any of these things necessarily create a problem, but because understanding your own record means you are not surprised by what shows up in an administrative proceeding. The third recommendation is to have an attorney identified before you need one. Second Amendment attorneys who specialize in exactly these kinds of administrative proceedings are the people you want to have a relationship with before a situation arises, not after. Know who you are going to call. Have their number saved. Understand generally what your rights are in an administrative proceeding so that if you find yourself in one, you are not starting from zero. The fourth recommendation is to stay engaged with the legal challenges that are already being mounted against the ruling's framework, because this ruling is not the end of the fight. Second Amendment organizations are already preparing constitutional challenges to specific applications of the expanded administrative authority framework. The arguments that the dissenting and concurring justices made about due process and the proper limits of administrative power are going to form the foundation of those challenges. Your awareness of and support for those efforts matters. The fifth recommendation is one that sounds simple, but is genuinely important. Be careful right now. In the current legal environment, with an expanded administrative framework now validated by the Supreme Court, the cost of any situation that draws official attention has gone up, not because you have done anything wrong, but because the pathways from official attention to administrative determination to gun rights implications are now broader and better defined legally than they were before this ruling. Being careful is not being afraid, it is being smart. Let us step back for a moment and look at the biggest picture of all. Because the fear that this ruling is generating in the gun owner community is about more than the specific legal provisions it establishes. It is about a direction, a trajectory, a sense that the administrative and legal frameworks surrounding gun ownership are moving in a direction that is not friendly to law-abiding gun owners, and that this movement is happening through mechanisms that are harder to fight than straightforward legislative restrictions. When a legislature passes a law restricting gun ownership, gun owners can see it clearly. They can organize against it. They can vote against the politicians who supported it. They can challenge it in court as a specific legal text. Administrative frameworks are different. They expand incrementally. They are applied case by case. Their implications are felt individually before they are felt collectively. And by the time the full scope of what has been created becomes clear to everyone, a lot of people have already been affected. This is what the most thoughtful gun rights advocates are saying about this ruling. The fear it is generating is not just about what it does today, it is about what it enables tomorrow, about what it makes easier, legally and practically, for governments at every level to do in the years ahead. The Supreme Court just expanded the space within which administrative determinations can affect Second Amendment rights. That space is now going to be occupied by state agencies, by local courts, by federal programs, by advocacy groups pushing for new applications of the framework. How it gets occupied, in ways that respect the rights of law-abiding gun owners or in ways that erode those rights incrementally, is going to be one of the defining legal and political fights of the next decade. Every gun owner in America has a stake in how that fight turns out. The fear is real, the stakes are real, and the time to understand what is happening is right now, before you find yourself in a situation where understanding it is no longer optional. This ruling changed something. The gun owners who are afraid know it. Oh, the attorneys who are preparing to fight it know it. And now you know it too.